All right, we have one more case. I've come in, Judge Sasso's come back, but we know each other, so. Is it, how do you pronounce your client's name?
My last name?
No, your client's name.
PICCININI.
PICCININI. I wouldn't have gotten that right, so. PICCININI versus State. Ready to proceed?
Good morning. It's still morning, I think. My name's Elizabeth Harris, and I represent Mr. PICCININI. And in our briefs, we've highlighted two comments by the court, and I'd like to begin by focusing on those two comments. We maintain that the judge, during the course of the defendant's direct testimony, defendant has testified on his behalf. The defendant is testifying with respect to a pending paternity action. And the judge, in response to the defendant's answer, says, well, I don't know if that's true.
Was there an objection to that comment?
No, sir, there was not.
All right, so your burden then is to, then the analysis is a fundamental error analysis.
That's right.
Okay. How does that one isolated comment go to the essence of the verdict in this case? And how do you establish that?
Well, I think what we have to do is, in this case, this is circumstantial evidence case. The defendant's testimony, his credibility was the very heart of this case. He has testified all along
there's
that
a fair amount of evidence. Call it circumstantial evidence. Circumstantial evidence is
still
not,
evidence.
It's evidence. And there's a fair amount of evidence in this case. And so the fact that it's characterized as circumstantial, I don't know what that does for you, but again, let me let you go ahead and finish that.
Well, I think what it does for me is because his credibility is so important here as he's maintaining, I don't know what happened. That's what he has maintained throughout the entire case. And so when he is coming forward.
A little bit more than that. First he says the dog ran into a wall. The dog's collar got caught up on a table. Oh, this group of people outside the house, they must have done it. So he's given a number of stories about how this all occurred. It's not just, I don't know what happened.
Oh, I don't know if I fully agree with that. I actually don't agree with it because I think what we have from the dog's owner, she says all along he has said, I don't know what happened, and that they continually speculate. And I think the speculation that goes on causes a lot of uncertainty as to precisely what's said.
Well, there was conflicting evidence on that. Some witnesses said he said the dog ran into a wall, and other witnesses said, well, he said maybe that happened, right?
Well, I think if you look at the detective's testimony, the detective says, and I wrote down the page number, I think if you look at page 320 of the trial transcript, the detective says throughout his entire conversation with the defendant says, I don't know what happened. I don't know what happened. So I think the detective, his testimony is at odds and ultimately corresponds with the dog owner's testimony, that she says he always said, I don't know what happened to the dog. We talked about the collar, we talked about this, and speculation. That's her word. We speculated. So when
there's evidence that whatever happened to this dog while he was there with the dog alone. And so getting back to the issue, which is how do you establish this one isolated comment, which for my purposes I agree was improper. So I'm going to start with that premise. In my view, the trial judge shouldn't have been commenting about the evidence, and this was a senior judge who theoretically ought to have known better. But how do you get from that isolated comment to the burden you need to establish for fundamental error?
I think we can't have a judge in the judge's unique position saying the defendant's testifying falsely on this point. Anytime the judge in the statute talks about...
Well, what he says is, I don't know if that's true. He's not necessarily calling them, saying it's not true. He says, I don't know if that's true.
Well, and I would direct you to the comments that occur in the bench conference just prior to that, because I think at that point the judge did know it was true. Because if you recall, there's a bench conference, and the comment is, what's the gist of what you're trying to ask? And she says, well, there's an agreement that this is going, the paternity action is going to await the criminal trial. And he says, well, go ahead and ask that question then. She goes and asks the very question he told her to ask, and he makes the comment, I don't know if that's true. And there's no correction after that. So when we have a judge that's
There was no objection, no request for a correction.
I agree. But the jury is left with the impression that the judge believes that what the defendant has said is not true. And I don't know that we can get to the point where we can disregard the case law that says the influence the judge has on the jurors in the unique position that the judge, in this case, a male judge, so I want to not trip that up.
That is
that he
the
says,
general proposition in the case law, but how do you square that also with the case law, for instance, in Randall v. State, Supreme Court precedent, saying that a judge's general comments are not going to rise to fundamental error, especially when, as the judge here, instructed the jury to consider only the evidence and, not to consider anything he said in support of either party. We're bound by
I
that.
don't think this is a general comment. I think it's specifically directed to the testimony of the defendant. And I think when we look at the instructions that are given, and those you'll find at 499, 501 and 505 of the trial transcripts. If you look at that, the judge says, please disregard anything I may have said which gives you the impression I prefer one verdict over the other. And he talks about weighing the credibility, that it's your job. But he has directly commented on this defendant's credibility. He has said, I don't believe that's true. And in light of that, we have the jury walking away with the impression the judge has assessed, and if he's not been truthful in that regard, what else has he not been truthful for?
Now, how important was this point, though, really? I mean, we weren't talking about a key issue in the case, right?
No, I don't think we were.
Well,
but
I mean,
I don't know that makes.
Is there any question? Do you have any question that this was, whether or not this was an important issue in the case?
I don't think it was, but I don't think it matters. I think if he had said it's
well, your argument would be
Wednesday,
your argument would be a lot stronger if it was related to an important issue in the case, wouldn't it?
the credibility is the important issue.
So you don't
His
think
credibility
you don't think your argument would be stronger if the judge said this about a key issue in the case?
I think I have to say yes, it would be.
The defendant
Of
got
course
up and
it would
said,
be.
the defendant got up and testified, I never said that the dog ran into the wall. I was just speculating. And the judge says, I don't know if that's true.
Sure. And that's
Your argument's a lot stronger then, right?
Absolutely. If we were to take, but I think credibility is the heart of this. And when we have a judge impugning that credibility or commenting on his veracity.
Well, why wouldn't the jury have just assumed that the defendant just didn't know the procedural posture of the other case?
But is that the position that we can take? Because our case law really tells us the judge needs to be extremely careful in commenting or suggesting the judge's perception of the evidence. And here we have him clearly saying, I don't think that's true.
But doesn't the necropsy that was done, doesn't that really go much farther in terms of his credibility? I mean, his statements are completely inconsistent with the results of that examination.
We have a defendant that has taken the stand and testified that I didn't do this. I didn't do these things. The judge has then said to the jurors, in the presence of the jurors, I don't believe this part that he has said, I don't know that that's true. I don't know that we can say that the jury was not affected by that. And I would suggest that it's outside the tasks that are assigned to the judge. The judge can manage the courtroom, the judge can clear up uncertainties or ambiguities, but I don't think that this falls into any of those.
Yeah, I have no idea why a judge would comment upon the evidence, but again, the analysis has got to get back to whether that really inhered in the return of the verdict?
Because we have the defendant coming forward testifying, and he consistently, and I would say there is consistent, even by the detective's statement himself, that he told me, I don't know what happened. And I gave you the page number on that, and I'd ask you to go back and take a look at that, because the officer is pretty clear on that. The second statement that I'd like to spend some time talking about is the statement at sentencing. So our position is...
Let me ask this. Was the stay entered on the sentence in this case?
No,
All right, so your client's done with the county jail time.
done with county jail time.
And so what you're addressing then is the community control and probationary aspect of the sentence.
That's right.
Okay.
That's right. So in the course of this, in the context of this, this defendant scored non-state prison time. And under the statute, the judge can exceed that non-state prison time, that presumptive sentence, if there's a question that non-state prison would pose a danger to the community. So in that respect, the
First,
defendant...
under my analysis, the jury has to do that. Well, not my analysis. Under the Florida Supreme Court analysis, the jury would have to do that, and the jury didn't do it in this case.
That's right. I think, and that was the position that was taken, was there was a motion to file that. But at the time that this was going on, and I don't know if this has been resolved, the first DCA had issued some case law that said Apprende applied, and the fourth had said differently. So there was kind of a question, there was some uncertainty, and there was no direction from this court at the time. And I don't know that there has been since this. But nonetheless, that's the context that this is coming in the context in which Dr. Cohen came in and testified. And he's very clear when he talks about the issue of responsibility with respect
All
to
right,
this.
but if that's the issue, the trial judge didn't go beyond the county jail sentence, and so the judge didn't impose a state Department of Corrections sentence. And so to that extent, I don't know, where there's any prejudice to you, because if that was the purpose of all that testimony, was to avoid a finding of dangerousness, then it succeeded.
Except for, I think we have a clear comment that he is bothered by this, and so he has sentenced him as severely as he could under the available sentence. And he's pretty clear, I'm bothered by this. And that I believe it was the Davis
So
case.
you want us to do what? We can't do anything about the county jail, that's done, because there was no stay entered. So we would remand this for a new sentencing to accomplish what?
Well, complete, that he'd be done with the sentencing. The probation would be lifted.
Well, not
that would be what we'd
necessarily.
be asking for, right? That this term of probation be eliminated.
And the community control.
And
Is
community
he
control.
done? He's not done with the community
I
control.
think he may have just finished community control in the last weeks.
Okay, all right.
But it would certainly, with respect, he still has a significant amount of probation.
So it wouldn't be for
And probation's
resentencing?
not an easy thing for anyone to
So
do.
it wouldn't be for resentencing?
On this, it would be resentencing, yes, sir.
Okay.
That's what we would be asking for. And I would just direct, I believe the case is Davis. It's it's very, very close. And in Davis, the court found that the comments were inappropriate and that he had exceeded or relied on impermissible factors in sentencing the defendant.
I think I understand your argument. You're essentially saying, look, we offered this testimony for a different purpose, right? But nevertheless, explain to me why that matters. You nevertheless offered the testimony. It was, your witness. Taking responsibility was introduced at sentencing, right? By your client. Yes or no?
I think the word responsibility, though, is subject, it's kind of a hokey thing to say, but it really is subject to interpretation. We're not talking, and Dr. Cohen was clear, we're not talking about accepting culpability. Not, I'm taking responsibility for my actions. He's talking about responsibility in that he goes to work, he does his chores, he's attended school. He's talking about, and he's clear about that in his testimony. He says, I considered responsibility above accepting culpability. So I think analyzing that word here is appropriate. And that's not what Dr. Cohen was looking at exclusively, and he's clear, and I can give you the
You mean Dr. Cohen was talking about responsibility in a much broader sense?
much broader sense. He talks about, I'm not looking at whether
But if we're talking about responsibility in a very broad sense, then why isn't taking responsibility in a very narrow sense relevant to that?
Well, and let's keep in mind what he's talking about the factors for psychopathy. So he looks at those factors and he scores a 0. And among those is this analysis of whether this is an individual that takes responsibility in life. Does he go to work? Does he pay his bills? Those are the things that are looked at. And that's the context in which this was introduced. It's very narrow in terms of whether there was a psychopathy or some type of mental disorder that would be a predictor or a potential risk for future dangerousness, if we want to phrase it that way. That's the extent in which this was provided, not in terms of culpability for the offense. And so I think that's where the problem lies, is that the judge says, I have a problem, you didn't take culpability, which directly impugns his due process rights.
So would it be your position that, showing responsibility for actions has to be specifically introduced as a ground for mitigation rather than relevant to a separately introduced ground in order to be relevant?
I'm not sure, I apologize, I'm not sure I understand your question.
It came up in the context of whether he's a threat to the public, right? Would it be your position that you would have to specifically introduce remorse or something like that as a ground for mitigation in order for it to be relevant for the judge to comment on?
I think that's absolutely correct. And the case law would support that when we're talking about rehabilitation or having demonstrated remorse, that's when this idea can come in, and that's not what happened here. What happened here is the doctor's reporting what is analyzed in a psychopathy testing. And in that conversation about what the factors are, this is where we begin to talk about responsibility in the broad term, responsibility in life, not culpability, accepting culpability for this offense.
And again, there was no objection to that, correct?
No.
So it's a fundamental error analysis on that issue as well.
I don't know the answer to that question.
Okay.
I would say no, but I don't know the answer to that question.
Okay.
All right, I'm going to reserve the rest of my time for rebuttal, if I may.
Okay, thank you. Let's start with the last issue and then let you work backwards from that.
Okay. First of all, I have an answer to your question. Yes, it's a fundamental error analysis. She didn't object below. And if they had objected, maybe they could have clarified it. But given the testimony of this psychologist, we would submit this is exactly the context he was testifying in. On page 301 of the record, he says...
But listen, every defendant tries to establish mitigation. That's the nature of sentencing, is that the state presents evidence as to what sentence they want and why they think it's aggravated, and the defense presents mitigation. And so the fact, and that's in every single case where you're having a criminal sentencing. And so the mere fact that a defendant asks for a lesser sentence doesn't open the door for a consideration of remorse. What I want to know is, why, Judge Sawaya's opinion doesn't specifically address this situation where the defendant, and I'm talking about, Corbett, where the defendant has maintained his innocence throughout the case and maintained his innocence during the course of sentencing. Why isn't Corbett, very clear that when that occurs, a judge commits fundamental error to this discussion or a finding of lack of remorse?
Well, this isn't just any case. I'm sorry, my time's not running.
Oh, I'm sorry.
This isn't just any case where the defendant maintained his innocence, pled not guilty, went to trial. That's totally fine. This is a case where the defendant pled not guilty, went to trial, and made dozen statements blaming everybody you could think of. I don't know what happened. It was your dad. He was here. I honestly believe that he had something to do with it. You know, I saw some kids walking away from the door. They might have something to do with it. He was blaming other people. Plus, he put on this testimony of a neuropsychologist. He brutally killed this dog. Everybody, you know, knows that animal cruelty leads to people cruelty and all of those ties that, you know, it's a bad thing that he did. And he was trying to say, look, not a danger to the community. And he put on a psychologist who said, here's what I look at when I'm deciding whether or not this is really an animal abuser or not an animal abuser. He's dangerous in the future or he's not. He says on page 301 of the record, I give them the opportunity to sort of tell their story the way they want to tell the story, and I see the way that they take responsibility or don't take responsibility, the way they emphasize with people in the case. So he's specifically referencing the way they take responsibility for their actions in the case. Later on cross-examination, after the prosecutor has asked a lot of questions about this taking responsibility thing, he says, so in this case, the defendant says he doesn't know what happened. Psychologist says, yep. He says, I have no idea what happened. He's really upset about it all. He says, the prosecutor said, so if I show you a video of him beating the dog to death, would that change your opinion based on him saying, I don't know what happened? Would that change your opinion on him taking responsibility? The psychologist says, yes, it would.
So my question
it
is,
in this context.
when the way that the defense framed it, though, in their questioning, and I recognize that exchange took place, but the way that the defense framed it was always, what is your opinion as to his future risk to the community?
Right.
Which seems like a different ground than whether this person has taken responsibility for the crime. And then when you look at the case cited favorably by this court in Strong v. State, the third DCA case, Lawton, it was a similar issue where the state had kind of elicited some testimony regarding remorse, and Justice Legault, writing for that court, said that wasn't sufficient to excuse the judge's comments in questioning or in sentencing. So how is this different?
First of all, this isn't the state bringing this up. This is the defense bringing it up. To say this guy is not a psychopath. He was trying to say he's not that dangerous. I know we have these awful, awful facts where he, you know, beat the dog and you know, it died, choked on its own blood. I mean, it's brutal facts here. This guy's not a psychopath. That's why he called the psychologist. He says, and one of the things I take into consideration when I'm evaluating this, and he scored a 0, is does he take responsibility in this case? He says, he said, I have nothing to do with it. The state specifically clarified if it was obvious he did, because the psychologist wouldn't bend when he said, but he was found guilty. Yeah, you know, that happens, but he says he doesn't know what happened. Do you think it's appropriate
to allow an inartful wording on behalf of a witness to dictate what a defendant is introducing?
I don't think
or
that
what
this
grounds
was
for mitigation?
artful. I think this was the psychologist saying, when I decide if somebody is a psychopath, somebody who's committed animal cruelty is a danger in the future, a danger to the public, one of the things I look at is, are they capable of feeling empathy? This guy says he doesn't know what happened. He says is he taking responsibility? I think he is. And then the state says, okay, let's talk about what that means to take responsibility. It's not, I pay my child support. It's, if I do something wrong, I admit it and I take responsibility for it. That doesn't mean he has to plead guilty, but this guy did more than just go to trial. His right to trial, that's perfectly fine. That can't be held against him. He also blamed every single person he could think of, including
So every time a defendant puts on a defense, that will, and the jury rejects that offense, the judge then can consider a lack of remorse?
Absolutely not. When the defendant blames other people and then puts on a psychologist who says if he blamed other people, he might be a psychopath, the judge is entitled to say, well, you say he didn't blame other people, but I was at the trial and he blamed everybody he could. And all it was a passing comment. He didn't sentence him above the non-state prison sanction. He didn't find he's future dangerous. He just called his bluff.
Well, but he did give the maximum sentence, well, I mean, he could have given,
5 years.
yeah, he could have, well, he couldn't give him 5 years in prison without making a finding that he was a danger to the community.
You would have had to make a finding he was a danger to the community.
Yeah, I guess this case was, at the time of sentencing, that line of cases hadn't really been clarified.
There were conflicting cases.
At that point in time.
Right.
But, in terms of not making that finding of future dangerousness, he gave him, a fairly hard sentence.
He could give him up to, 51 weeks, 6
Yeah.
days. He got 51 weeks.
Well.
He gave him a hard sentence. He strangled the dog and then
I'm
beat it
not
to death.
suggesting, all I'm saying is that you had these issues there, and so the sentence was in terms of a sentence without making that finding, this was about as harsh a sentence. He could have given him, I guess, 4 years of community control.
Without making that finding, right. This was, it's not an easy sentence without making that finding. But he didn't make that finding, and he, commented that he did not find the psychologist to be credible. And it's when he's talking about that he says, you're saying he takes responsibility, scores a 0 on my test. I'm telling you, I saw the evidence. This is not a guy who's taken responsibility. He's just responding to the defense evidence. And they don't get to present evidence and then say, you can't
He's going
talk
beyond
about
that, though. He says, doesn't he say something along the lines of, what concerns me is that he hasn't shown any remorse and he hasn't, and that, it seemed like to be the only comment he made in justifying, not that he needed to make the comment, but in justifying the sentence.
Well, he said the other thing that really bothers me is I've heard Dr. Cohen's testimony, that's a psychologist. I don't see that he took any responsibility for anything that happened to the dog. He blamed the neighborhood kids. He blamed the father of the owner of the dog. He even kind of blamed her. Everybody was blamed except him. He even commented to the PSI official that he should have chased after the kids in the neighborhood because they probably had something to do with this. I don't accept the testimony from the psychologist. That's what he was talking about it in that context. And the testimony from the psychologist was, this guy scores a 0. He's not dangerous at all. And one of the things I consider is that he takes responsibility. And the court said, no, he doesn't. So I'm not accepting that testimony. But I'm not going to find that he has future dangerousness. I'm not going to sentence him to 5 years. I'm going to give him a non-state prison
But isn't there a distinction between making a finding that you don't accept the psychologist's opinions based upon this set of facts, and then saying, right before sentencing, that I'm bothered by the defendant's lack of remorse? Isn't there a distinction between those two?
Don't remember where he says I'm bothered by his lack of remorse.
Gist of it.
Well, he says he's taken no responsibility, which he's talking about in the context of this guy scored a 0. He's not dangerous at all. That, I believe, is what the context of that is, the taking responsibility. And I would submit that's not erroneous. The defendant put that on. The court has the responsibility to accept it or reject it. He scored a 0. I don't think your test is real great. If part of your consideration, which you said it was, is whether or not he takes responsibility in this case. Because I heard the testimony and he doesn't, and he's still blaming these mystery kids. So that's not taking responsibility. We don't accept your 0, but I'm not going to give him 5 years either.
Yeah, he does. He puts it in terms of responsibility, not remorse.
Right.
That is accurate.
And we would submit that the defense introduced this responsibility issue, backfired on him. The court is entitled to comment on it. It's not a generic situation where because he went to trial, the court finds he doesn't have remorse or didn't take responsibility or slamming him for exercising his constitutional
Would you like
rights.
to address the other issue
The
raised?
other issue raised here today was about the inappropriate comment by the court. They kind of went off on this
Do you
tangent about the
concede it was an
paternity case.
inappropriate comment?
It's hard to tell on a cold record. It's not, certainly when you read it on a cold record, well, I don't know that that's true. It's not a great comment by the trial court. Yes, we would agree with that. When you view it in the whole context, though, they're going off on this paternity thing, and they're talking about the procedural aspects of it. We don't know how the court said that, if he said it very confrontationally, if he said it muttering to himself. We don't know. That's why you object in the trial court, so that the court can say, well, I was just muttering. I don't think the jury heard it. Or defense counsel could say, you just looked at my client and said, I don't believe anything you just said. There's different ways of that sentence could be uttered, first of all, which is why you require an objection to this kind of a thing. But what he said is, I don't know that that's true. Come on up here. They talked about it. It was true procedurally. They were staying the paternity action until this criminal case was resolved. And they went back and they never corrected it. They never said, no, it's not true that the paternity case is stayed. They said, so the paternity case is going on and she's told you basically, I'm going to lie if I have to, so you can't see our kid. That's how that proceeded from there. And given that, is that fundamental error? The jury could not have reached its verdict without that error. We would submit that's not even close. If they had objected below, they could have fixed it. That's the point of requiring objection. It's an easy fix, plus it would have clarified the record. A cold record, it's hard to tell the tone. It's hard to tell if he was questioning or accusing. I mean, we just don't know. They have to demonstrate fundamental error, and we would submit they have not met that burden or even come close to it. The other issues she has not raised, so unless the court has questions about any of those, I will rely on my brief and ask you to affirm. Thank you.
Thank you. Well, you've got a little over 2.5 minutes.
I'd like to go back to your question.
I'd like to know, do you agree that Dr. Cohen's opinion was in part based upon the defendants taking responsibility in this case?
No, I don't.
Do you disagree with that?
I do, and he tells us that he tells us that I'm not just looking at whether he takes responsibility or not for the current issue. I'm looking at other aspects as well.
I'm not just looking at. So does that mean that it was part of his consideration? I mean, that's the question. I'm not asking if that's the only thing you looked at. I'm asking, was it in the mix?
He does not tell us. I asked him, did you do this? I don't recall that he testifies. I asked him, did you do this? And he said no. I don't recall Dr. Cohen testifying to that. And I would say that if we accept the state's position, a defendant who maintains his innocence, in order to have a credible psychopathy test introduced, would have to admit guilt. And it puts the two things at odds. If we go down the path the state has suggested, he would have to have come to the psychologist and said, yes, I did this, I am admitting guilt, even though he's maintained his innocence, or it gets thrown out as not credible. Or opens the door for this idea of lack of responsibility coming in as a basis to augment a sentence. So I think the two things pose a real dichotomy that can't be resolved under what the state is asking us to do today. I want to go back to your question, Judge Eisnagel, about whether the paternity was important here. And I want to readdress that issue, because when we look at what the defendant is testifying to, he says, she said, I will say whatever so that you can't be near our child. And that's the gist of when this is coming out.
Except her testimony wasn't critical to whether or not, other than the fact that he was the only person alone with the dog at the time that these injuries occurred, and I don't think that was disputed. Her testimony wasn't the testimony, it was really the vet and the other experts' testimony that really was critical on that issue.
Well, I don't know that her testimony really matters in terms of this analysis, because the position that I would be asserting is the reason the paternity is important is he's placing a context, and he's saying, she said, in essence, I'm gonna continue to pursue this because I don't want you to have visitation with our child. And so when he is making this is the gist, the context in which that comment is being made, and why it is important, and why the judge saying, I don't know if that's true, is significant to the jury.
All right, thank you.
Thank you.
All right, we'll be in recess for the morning, or the afternoon now.